But the outcome is going to be predictable because the people who sit on it are never going to vote in favor of Bangladesh anyway.
The history of the regime is to discipline newly independent countries that had been colonies and to protect economic interests of the former colonial powers.
When a piece of infrastructure operated by a foreign company explodes, who would you expect to find themselves in legal trouble? Who should decide guilt? And who should get paid damages? Who gets heard and who gets left out of the process altogether? I'm Paul Gilbert, and in this episode, we'll be talking about a gas well that exploded in northeast Bangladesh. We'll be looking at a whole range of court cases and accusations involving government, corporations, and civil society organisations. But I've misled you a bit because the case we're about to investigate isn't really just a story of who did what to whom. It's about so much more than that. It's about how international law is an instrument of colonial power. As we'll see, the legal wrangling that followed our moment of infrastructural failure reveals a great deal about how international legal norms, created by former colonial powers, preserve those powers' global strength and dominance. These norms have allowed a small group of international lawyers to determine if and when foreign investors need to submit themselves to the authority of national courts. And, in the process, everyone except those directly affected by infrastructural breakdowns get to have their day in court. You are listening to Material Crimes, and this is the story of the Tengratila blowouts. Before I get into it, I should probably tell you what a blowout is. Well, you'll all probably have seen pictures of one. It's when the pressure systems at a gas or oil well fail, shooting a jet of highly combustible gas into the air and leaching gas reserves into the surrounding environment. And, on January 7th, 2005, a blowout occurred at the Chatak 2 natural gas well in Tengratila, near Bangladesh's northeastern border. Then, in June of the same year, a second larger blowout occurred when attempts to drill a relief well went wrong. The second explosion resulted in a blaze that burned for weeks. The fire rendered much of Tengratila off limits and caused destruction to local wetlands and cultivated ponds. Thousands of cubic feet of gas burned, churning out pollutants which were breathed in by local residents and the wetland fauna. But the longer-term result of the blown-out well is gas seepage through the Earth's cracked subsurface.
রাস্তাঘাট বসতবাড়ি শিক্ষা প্রতিষ্ঠান
10 years after the blowout in 2015, gas continued to pop, bubble and hiss as reports emerged of it escaping through cultivated ponds and tube wells used for drinking water, seeping into soil and contaminating adjacent wetlands. In some cases, local residents, lacking access to safely piped gas and having to deal with the aftermath of the explosions, sought to capture gas from their gas-filled ponds. Not long after the explosion, the Bangladesh Economic Association reportedly calculated the loss of gas in the upper layer of the Chatak field and the damages caused at over $1 billion. A government committee calculated the loss of gas at a more conservative amount of around $4 million. Numerous experts called for Niko, the Canadian company overseeing the drilling, to be held responsible. Newspaper reports from the time describe how affected families from Tengratila demanded housing rehabilitation and clean drinking water, and embarked upon 15 days of protest action in front of Niko's offices. So, in 2005, the Bangladesh Environmental Lawyers Association filed a petition with the Supreme Court, taking advantage of Bangladesh's public interest litigation provisions. I have the rather hefty court filing here in front of me. It charges Niko with gross negligence for failing to undertake their operations in a conscientious and workmanlike manner, and with utter incompetence in their drilling in Chatak. The petition also charged the government of Bangladesh and its parastatal firms responsible for oil, gas and exploration, that's Petrobangla and BAPEX, with gross failure to take appropriate measures against the respondent, Niko, to realise or recover adequate compensation for loss of country's natural resources. In the ruling, issued in 2010, which I also have here before me, Justices Kamrul Islam Siddiqui and Syed Mahmood Hussain ruled that Niko cannot avoid its responsibility of giving adequate compensation for the losses caused by 2 successive blowouts. In addition, the Bangladesh government was restrained by an order of injunction from making any payment to Niko until a money suit brought by the government in 2008 had been ruled upon. We'll get to that in a moment. This is where things get complicated, and we need to go back a bit to 1999, when Niko entered into a framework of understanding with BAPEX. BAPEX, like its parent Petrobangla, is headquartered in Coumans Bazaar, Dhaka's busiest wholesale market, not far from the notoriously congested Farmgate Junction. Following that 1999 framework of understanding, Niko entered into a joint venture agreement with BAPEX for the Chatak field, but also another field in Tengratila, the Feni field. This joint venture agreement is going to play an important part in this story, but for now, what's important to know is that the Feni field started producing gas and delivered that gas to Petrobangla in 2004, before the price to be paid per unit of gas had been agreed. Negotiations were still ongoing in 2005 when the explosions occurred at Chatak. So while the price was finally agreed in 2006, the government of Bangladesh did not want to pay Niko while the issue of compensation for the blowouts was outstanding. Withholding that payment acted as a kind of leverage. Remember that money suit I mentioned in the ruling on the Bangladesh Environmental Lawyers Association case? Well, that was a case brought by the government, which petitioned the Supreme Court to put a hold on any outstanding gas payments owed to Niko until the government had been paid compensation. The figure settled on in the money suit was 7.46 billion taka, that's the Bangladeshi currency, which is the equivalent of about $79 million at the time. So to recap, as I'm aware this has become rather detailed and technical, in 2004, Niko started producing gas in its Feni field and shipping it to Petrobangla until 2006. The price for this gas hadn't been agreed, but it was delivered nonetheless. In 2005, there were two blowouts in Chatak. BELA, the Bangladesh Environmental Lawyers Association, submitted a petition, which was ruled on in 2010, finding Niko liable for compensation and forbidding any gas payment for that Feni gas until compensation had been paid in the amount of $79 million as per the money suit brought by the government against Niko in 2008. There we are in 2010. Niko wants money for the gas it's delivered, Bangladesh wants compensation for the gas that was destroyed and the damage done to the surrounding land and livelihoods. And the courts do not want Bangladesh to pay for the gas until Niko has paid compensation for the blowouts which were ruled to be a result of negligence or incompetence. Except, it's about to get a lot more complicated, because in 2010, Niko filed two arbitration cases with ICSID, the World Bank's International Centre for the Settlement of Investment Disputes. One of these cases wants a ruling on the compensation claim by Bangladesh. The other case concerns Niko's demand to be paid for the gas it delivered, plus interest. But how can Niko, a Canadian company, although as we'll see, not entirely Canadian for legal purposes, just submit a request to overturn the rulings of the highest court of an independent nation? Bangladesh has appellate courts, why not petition for an appeal? And if you lose, well, that's what happens when courts find against you. What exactly is international arbitration, or ISDS, that is, investor-state dispute settlement, and what does it have to do with infrastructure, finance, and the afterlife of empire? I first became interested in ISDS when I was a PhD student, looking into UK companies investing in Bangladesh's natural resources. At investor roadshows and events designed for resource exploration companies to meet financiers in the City of London, I was struck by how often guest speakers would advise companies to ensure they had arbitration provisions in place before investing in supposedly difficult countries. On one occasion, I attended a training workshop for UK investors where a partner from a Magic Circle law firm advised attendees on how to creatively use ISDS to protect their investments, using an example from an old case that involved Bangladesh. Later, at an event organised by lawyers based in Dhaka, this same case study came up again, but this time it was treated completely differently. In London, it had been a useful lesson for how to protect your investment against all the odds. In Dhaka, the same ruling was seen as evidence of overstepping and lack of respect for Bangladeshi judicial autonomy or sovereignty. Gus van Harten, professor at Osgood Law School at York University in Canada and an expert on international investment arbitration, also found himself drawn to ISDS as a graduate student because, as he said to me, it seemed so extraordinary that foreign investors could sue countries directly. Here is Gus speaking on ISDS.
Today we have what I would call the closest thing you have to a world Supreme Court. That is an international adjudicative body that can review almost anything that countries do on behalf of their people. And they can hear directly from the foreign investors. The foreign investors don't have to go through the state's courts first. And they have extremely powerful remedy available, which is an uncapped damages award that's internationally enforceable. One of the main arguments made in favor of the regime is that foreign investors can't be expected to trust national courts. They're unreliable, they're not independent, they're corrupt. However, the logic of the system is to sweepingly dismiss national courts in every country by allowing foreign investors to bring claims internationally without ever having to explain what's the matter with the domestic court.
You heard Gus at the start of this episode telling us how the history of the investment arbitration regime was in disciplining newly independent countries, that is, former colonies, and restricting their decision-making powers. How does this work? Well, through agreements such as bilateral investment treaties, states effectively give investors the right to sue them through arbitration mechanisms like ICSID, which are globally enforceable thanks to their incorporation in the World Bank Group and the fact that many states have signed the ICSID Convention. The international investment arbitration system has often been criticised for favouring investors over states, particularly global south states, former colonies whose attempts to chart independent pathways to development, sometimes involving high taxation rates, nationalisation or capital controls, were viewed as threats that needed to be constrained by global north investors and their home state governments. Someone else whose voice you heard at the start of this episode was Muthucumuraswamy Sornarajah, a leading academic and arbitrator who has been influential in expressing global south criticisms of international investment law. I spoke to Sorna at his home in Jaffna shortly before the culmination of Sri Lanka's political and economic crisis in 2022. We spoke between the rolling power cuts that were already in place to deal with mounting energy shortages.
Ultimately, the treaty has to be interpreted by arbitrators, and the arbitrators are not leaning towards interpretations that are favorable to developing countries. If you are an arbitrator, you earn $3,000 a day, and if you are an arbitrator who has a lot of cases, you are going to earn $3,000 a day every day, That's $90,000, yeah? And you earn about $500 per hour for all the opinions you give, for all the statements that you read, for the travel that you undertake. You sit in a plane, sleep through the journey, and the journey is 10 hours long. You have $5,000 paid to you. So you earn in your sleep, really. So why would you give it up by making a decision that doesn't favor the law, that supports investment protection? Yeah.
And as to arbitrators' attitudes to the rulings of judges in global south nations,
the judgments are looked upon as not of any worth. And if you were to say that within Bangladesh, they would take you in for contempt of court. And here there are guys who are saying the same thing, sitting as arbitrators, and you respect them and honor them, and
As Gus van Harten will tell you, arbitrators are not judges. They are not subject to any of the classical judicial safeguards, long tenure, random allocation to cases, or prohibitions of working on the side as a lawyer. So the 3 arbitrators appointed to decide on a case could later be hired to work as lawyers for a company or one with similar interests whose case they were previously deciding upon. And arbitral rulings cannot be appealed. They're also not required to consistently use precedent, and this comes to matter in the Niko case too, as we'll see. But for now, let's return to the history of international investment law and the origins of investment arbitration in disciplining the states of the global south. Gus van Harten again.
The history of the regime is to discipline newly independent countries that had been colonies and to protect economic interests of the former colonial powers by ensuring there were constraints on the sovereign realm of decision-making that was available to newly independent countries. And they were historically concerned about expropriation and nationalization, but the treaties just morphed into something far beyond that, something just deeply anti-regulatory and anti-state.
In the 1970s, a number of lawyers from newly independent former colonies began to write critically about international investment law. How could this law claim to be international or universal when it had been developed by colonizers, and norms preoccupied with protecting the assets of aliens or foreign investors had been established without the participation or consent of the formerly colonized? Writing in the early 1980s, Ghanaian lawyer SKB Asante explained that, so long as it remains primarily preoccupied with the protection of foreign investment against the legitimate sovereign interests of the host state, international investment law would be perceived as inequitable by formerly colonized nations. Georges Abissab, another member of the network of Third World lawyers who were challenging the idea that the international legal system is universal and legitimate, and that new states should simply be born into that Western imperial legal system, ended up drafting the UN General Assembly's analytical study on the new international economic order. Remember those names, SKB Asante and Georges Abissab. We'll hear about them again soon. In 1974, a resolution on the new international economic order was passed by the UN General Assembly, asserting, among other things, the right of newly independent states to pursue development according to their own priorities, including the use of subsidies, nationalization and capital controls, as well as their permanent sovereignty over natural resources, or PSNR. Despite being passed, the new international economic order fell by the wayside in the 1980s. Defaults on debt repayments during the so-called Third World debt crisis in the early 1980s resulted in the IMF providing bailout loans that came with stringent conditions. These conditions constrained the policy sovereignty of former colonies, turning newly independent states into what Tandika and Mukandawire called choiceless democracies, effectively barred from any pathway to development other than liberalization and opening up of resources and industries to foreign investors. Today, the new international economic order, its moral claims and its political promise is either consigned to the dustbin of history or willfully forgotten altogether by many practitioners of international investment law. But Sornarajah, another member of that Third World Lawyers Network, had this to say.
It goes into eclipse, so to speak, but it's not lost because by that time, the new international economic order had been made into law in many countries. You find the rule relating to permanent sovereignty over natural resources. You find that in the constitutions of many of the developing countries.
And he was right. Article 143 of the Bangladesh Constitution is effectively an assertion of the permanent sovereignty over natural resources, and this claim by the Republic over its natural gas is part of the grounds for the compensation claims articulated in the lawsuits filed by Bella 2005 and the Bangladesh government some years later. The durability of the new international economic order and the Third World Lawyers movement can be detected elsewhere in the Niko Bangladesh case. After Niko filed for arbitration in 2010, Bangladesh's first nominees as arbitrators were none other than Georges Abissab and SKB Asante. Both were vetoed. Instead, the tribunal ended up being chaired by Jan Paulsen, whose own writings have been described by Egyptian international lawyer Amr Shalakani as epitomizing the pro-arbitration stance of northern scholars. For Paulsen, arbitration is a neutral means for the resolution of conflicts, to be mastered rather than complained about. From this point of view, there is nothing unjust about the presumption that the courts of independent global south nations can be overturned by private parties who seem to care a lot more about the protection of investors' assets than the broader public interest. Paulsen's most frequent sparring partner in the pages of international law journals, incidentally, is one Muthucumuraswamy Sornarajah. Let's go back over the fiddly details of the Niko case one more time. At our last recap, we covered how in 2004, Niko started delivering gas from the Feni field, and that went on until 2006. The price hadn't been agreed with Petrobangla, so no money changed hands. In 2005, 2 blowouts occurred in the nearby Chatak field, resulting in the destruction of vast quantities of gas, the constitutionally insured property of an energy-starved nation, and significant environmental and economic damage. Cases brought by the Bangladesh Environmental Lawyers Association in 2005 and the government itself in 2008 put a stay on any payment to Niko while ordering Niko to pay compensation for the destroyed gas. Since then, we've seen how Niko responded by invoking arbitration at ICSID, An arbitration tribunal was established, chaired by a long-time arbitrator who is not moved by the argument that investment arbitration reflects the interests of former imperial powers who see policy autonomy in the global south as a threat to their property, their assets and their revenue streams. But I left something important out. Also in 2005, in May, between the two blowouts, and while the pricing of the Feni gas was being negotiated, Niko delivered a car to Bangladesh's energy minister Mosharraf Hossain and paid for his travel and expenses to Canada.
It's most inappropriate for me to comment on an issue before the court.
The RCMP have laid fraud and breach of trust charges against former Liberal Senator Mac Harb.
That was Canadian former Liberal Senator Mac Harb speaking not about the Niko case but about an expenses scandal in the Canadian Senate in 2014. Harb's name came up in relation to Niko too, given that he travelled to Dhaka in 2005 to go to bat for Niko, and received $65,000 Canadian to do so, while he travelled on a kind of diplomatic passport. The Royal Canadian Mounted Police investigated him in 2011 on breach of trust charges, though none were filed. That was part of a larger RCMP investigation into Niko resources and the payment of bribes to the Bangladeshi Minister of Energy during 2005, while the gas pricing negotiations were still underway. Niko admitted fault and paid a $9.5 million Canadian fine, the largest to date under Canada's Corruption of Foreign Public Officials Act in 2011. It might sound like a lot, but Niko CEO Ed Sampson, once the highest paid exec in Calgary, earned $16.5 million the year before the ruling and $11.1 million in the year ending March 31st, 2011. And despite the involvement of celebrated businessmen and sitting senators, Canadian lawyers interviewed by the Globe and Mail still framed Bangladesh as the problem. As a lawyer for Osler, Hoskin and Harcourt in Toronto put it,
"It sends a very strong signal to Canadian companies that they can't do business in the local way."
Framing the problem as doing business the local way, rather than Niko's conduct, plays into the discourse we heard about earlier, where investment arbitration is justified because of the weakness or supposed corruption of global south courts. If they can't be trusted, why not use private international arbitration, right? But at times, Canadian extractive industry firms seem to suggest they'd prefer if people used national courts in the global south. Here's Catherine Coumans from Mining Watch Canada.
So about 47% of the world's publicly traded mining companies are on the Toronto Stock Exchanges, and many of those are headquartered in Canada. So we're talking about roughly 1,300 mining companies and exploration companies, and about half of those are operating overseas. And most of those countries that they're operating in are developing countries. Here in Canada, we have a group of civil society organizations that have been for years now fighting for stronger measures, regulatory measures in Canada, so that Canadian companies can be held to account in Canada for the harm that they're doing overseas. Because the Canadian industry has such a large footprint, because the Canadian industry is known for doing so much harm overseas, we've been saying for years, Canada needs to step up. And one of the ways that we want to be able to address this harm is to allow people to have access to our courts. Right now, that is very, very, very difficult. We want to make our courts essentially a place where people can come if their rights have been harmed by Canadian mining companies. And time again, the industry will shoot this down by saying, oh, no, that's extraterritorial. We don't want the Canadian government to be deciding what happens with our corporations when they go overseas. That's interfering with the sovereign rights of other countries, and those things should be before the courts in, say, Papua New Guinea or wherever else, Tanzania, rather than in Canada.
It was precisely this question of when to listen to the Bangladeshi courts and when to listen to the Canadian courts that became a major sticking point in the Niko arbitration. In 2015, after the ICSID tribunal had initially found in favour of Niko, insisting that Petrobangla and BAPEX pay Niko the amount due for gas delivered from Feni between 2004 and 2006, lawyers for Petrobangla and BAPEX contested this. No, they said, we now know there was corruption in relation to Mosharraf Hossain, and Niko has been found guilty and fined. Should the joint venture between BAPEX and Niko under which the Feni drilling took place not be deemed void? Why should Petrobangla pay for gas if there was a likelihood the contract was procured by questionable means? As Petrobangla and BAPEX's lawyers put it in their submission, Niko cannot use the international arbitration to assert claims associated with its illegal conduct. The arbitration tribunal took the view that the corruption conviction pertained to the determination of the gas price, which remember hadn't been decided when production started, which is why no payment was made. There was no evidence of corrupt behaviour in procuring the joint venture between 1999 to 2003. Petrobangla and BAPEX argued they should be able to view more details from the Royal Canadian Mounted Police, FBI, Anti-Corruption Commission and City of London Police's joint investigation into Niko. What if there had been more corruption? It doesn't seem a stretch given what we know happened in 2005 and Niko's conviction. BAPEX and Petrobangla wanted Niko's records. When Niko heard that the Royal Canadian Mounted Police were investigating them in 2009, their lawyers hired Deloitte to perform an audit. In Canadian law, this counts as privileged information because of the connection to the lawyer, so it could not be turned over to Niko. Canadian law would stand. It's probably worth mentioning at this point that the cases Niko brought against Bangladesh, BAPEX and Petrobangla was not based on a Canada-Bangladesh investment treaty, but a Barbados-Bangladesh investment treaty. Niko Resources Bangladesh is incorporated in Barbados and turns up in the International Consortium on Investigative Journalism's Paradise Papers database.
The Paradise Papers are the latest document leak to reveal how thousands of Canadians keep money offshore and how this problem is growing. What this one shows is the extent to which Canada has become a major player in this game. So, why hasn't Canada cracked down on the rules that allow this to happen? Good question.
Some politicians have tried to make the rules tougher, but instead of cracking down, Canada's made it in some ways easier to avoid tax this way.
Besides, the nail in the coffin for BAPEX and Petrobangla was that, in the judgment on Bella's 2005 petition, which we talked about earlier, the Bangladesh Supreme Court ruled that the JVA contract was not obtained by flawed process resorting to fraudulent means. This domestic court's judgment was reproduced numerous times by the arbitrators to justify their dismissal of the corruption claim. Several times over they insisted Petrobangla must pay for that gas from the Feni field. Of course, the Bangladesh Supreme Court made that ruling, suggesting nothing improper had taken place, a year before the conclusion of the Canadian corruption investigation and conviction of Niko. Perhaps they might have chosen their words more carefully or looked again if they knew they were dealing with a company that had already been convicted and slapped with a record-breaking fine for corruption. And even in that original ruling, you don't get the impression that the whole process was squeaky clean. Looking at the ruling, which I have before me here again, we can read that it is clear that inclusion of Chatak East in the joint venture agreement area was collusive and malified. Essentially, there was no evidence of corruption in obtaining a joint venture contract, but still, something wasn't right in the way the Chatak field was included in the contract at preferential rates without competitive bidding. And yet, none of this has made a dent on the ruling by the ICSID tribunal. For critical third world lawyers like Sornarajah, this doesn't sit right.
But the outcome is going to be predictable because the people who sit on it are never going to vote in favor of Bangladesh anyway. I think you have to study the record of people. I mean, you look at the corruption decision. I mean, there seems to be a lot of proof, lot of evidence as to corruption, which was believable, you know. But they come to hold that there was no corruption, which is not believable. So that's the way things go, yeah. So you earn in your sleep, really. So why would you give it up by making a decision that doesn't favor the law that supports investment protection? You hold that there is no corruption, but in fact, there is evidence of corruption, you know. That's a bit sad.
The arbitration tribunal was keen to uphold the decision of the Bangladeshi courts that the agreement with Niko was not obtained by questionable means, even though this ruling was made before the Canadian corruption investigation was complete. Yet elsewhere, they were only too happy to refuse to acknowledge the authority of the Bangladeshi courts, such as with the injunction against the Bangladeshi government making payment to Niko that was handed down in the Bella ruling. So in 2016, another petition was submitted to the Bangladesh Supreme Court, this time by Shamsul Alam, petitioning for the confiscation of Niko's assets precisely because of the evidence that came to light in the investigation that led to Niko's conviction in 2011, after the Bella ruling. Which, by the way, the arbitrators still cite as a reason to dismiss claims that the joint venture was tainted by corruption. The court ruled in favour of Alam and his petition. They seemed convinced by the evidence of corruption put before them and ordered the confiscation of Niko's assets so that compensation could be paid to the state of Bangladesh and those affected by the blowouts in 2005. The arbitration tribunal's response? to once again assert their sole jurisdiction over that case and to refuse to acknowledge another ruling by the Supreme Court in Bangladesh, and insist once more that Petrobangla pay for the 2004 to 2006 gas, plus interest. Then, in May 2020, a series of press releases announced that the tribunal had found in favour of Bangladesh in the compensation part of the case. Niko was liable for the blowouts and would have to pay. There was no movement on the payment claim, no acceptance that corruption was involved, and the courts gave a final order for Petrobangla to pay for the gas, interest and legal and arbitration costs in September 2021. At the time of recording, that May 2020 ruling still hasn't been made public. We only have press releases from the Energy Ministry in Bangladesh and BAPEX and Petrobangla's lawyers. If that ruling went in Bangladesh's favour, that would be quite something. Except, while the arbitrators ruled that Petrobangla must pay Niko for their gas, they refused to set aside the award until a compensation claim had been made, despite protestations from Petrobangla and BAPEX that Niko might not be in a good position to pay, should they later win the compensation half of the case. And it doesn't look good.
It may be the end of the road for Niko Resources. The Calgary-based company, which has almost all of its assets overseas, put itself up for sale this morning. Just 4 years ago, Niko stock traded at about $100 per share. On Wednesday morning, the stock was around 25 cents per share.
Reports have emerged of Bangladesh seizing some of Niko's assets in response to the May 2020 ruling, but the lack of a final public report means that this is perhaps not quite over. And even if Bangladesh did win, or at least not lose the compensation claim, why should they have to have waited for the ruling of their own Supreme Court to be validated on the whims of international arbitrators with an interest in perpetuating an opaque and asymmetrical legal system? In Tengratila today, compensation from Niko is still some distance away. When the ICSID compensation case is over, perhaps there will be an award to the state of Bangladesh. But one of the biggest injustices of the international arbitration system, as Gus van Harten is often at pains to point out, is that most affected parties have no legal standing. Private investors or corporations can initiate arbitration, states can respond. No one else has the right to be heard or be a party. Sometimes, on the whim of arbitrators, communities that have been displaced or exposed to environmental harms by an investment can be heard by the tribunal, if that tribunal chooses to allow amicus curiae or friend of the court status. But there is no mechanism to enforce an award against a company to those affected by its negligence, and there are no responsibilities placed on companies like Niko in tandem with the rights that they have to seek private justice outside the state. This episode has been littered with details of numerous crimes and endless court rulings. Putting them back in chronological order, it seems that sometime around 2003, Niko secured the rights to Chatak at unduly favourable rates without competitive bidding. In 2004, they started producing gas at Feni. In 2005, they seemingly bribed the Bangladesh energy minister. Also in 2005, there were 2 blowouts at Chatak. Petitions were filed by Bangladesh Environmental Lawyers Association in 2005 and the government of Bangladesh in 2008. The courts in Bangladesh ruled that Niko must pay compensation, and Bangladesh and its parastatals must not pay for the gas received from Feni until such compensation was received. Niko went to ICSID and initiated arbitration in 2010, and in 2011 they were convicted of corruption in Canada, receiving a record-breaking fine. In 2014, and then again repeatedly until 2021, the arbitration tribunal repeated its ruling that there was no relevant corruption and Bangladesh must pay Niko for its gas. Meanwhile, in 2016, another petition with the Supreme Court in Bangladesh ruled on the confiscation of Niko's property for restitution. Then, finally, it seems that in 2020 the arbitrators found in Bangladesh's favour in relation to compensation, although the publication of these details is still pending. At no point, except to highlight an early pre-conviction finding that the joint venture with Niko wasn't corrupt, did the arbitrators defer to the Bangladeshi courts. And at no point did affected residents of Tengratila participate in these proceedings. Having spent countless hours trying to untangle all of the legal chicanery involved in this case, I find it hard to share with the arbitrator in these cases, Jan Paulsen, the view that arbitration is simply, and I quote, a neutral means for the resolution of conflicts, to be mastered rather than complained about. The other episodes in the Material Crimes series have focused on hard, tangible forms of infrastructure, railways, ports and bus stations. This episode started with an archetypal piece of physical infrastructure too, a natural gas well. When infrastructure like this works properly, we don't tend to notice it much. Infrastructure presents itself as relatively banal, and the power relations behind the operation of that infrastructure fade into the background. But in moments of crisis and volatility, like the blowouts at Tengratila, land, livelihoods and people's bodies are all of a sudden exposed to the devastating consequences of infrastructural collapse. But infrastructure is not only the physical stuff that forms the bedrock of economic and social life, movement and distribution. For many investors and policymakers, infrastructure is first and foremost an asset class, something you can think of in terms of the cash flows it will provide for you, rather than physical foundations. If that's how you relate to infrastructure, then making sure you have legal backstops to ensure you can get hold of those cash flows, even if the physical infrastructure itself breaks down, is a top priority. And as we've seen in the Niko case, ISDS, Investor-State Dispute Settlement, a system of international investment law inherited from the age of formal empire, has become just that. ISDS has protected and recovered the financial value of infrastructure, even if the corresponding physical infrastructure has collapsed, and continues to leach natural gas into the surrounding ponds. There have been many, many rulings related to this case, on corruption and on compensation, but there has been no opportunity for residents directly affected by the blowout to hold Niko to account, domestically or internationally. Not every injustice gets to count as a crime. Not everyone will even get a shot at justice, so long as our colonial system of international investment law remains primarily preoccupied with the protection of foreign investment above all else.
Wow, what an episode. We are so excited to be in the studio today with me, Dr. Chantal Jessica-Lewis, Maya and Shari, amazing producers, and the star of this episode, Paul, another amazing producer, curator, the brains behind this incredibly thorough, legally mind-blowing, so much detail and really bringing to the fore like the kind of administrative crime alongside the physical, like literal blowout explosion crime of the Tengratila explosion. Thank you so much for putting together this episode, Paul.
Thank you for having me on the series.
Paul, it'd be really great to just talk a little bit about why you chose this topic. What is it about this area, this material crime? What brought you to this work?
Okay, yeah. So it started during my PhD when I was looking at the relationship between UK-based investors and financiers and coal and gas projects in Bangladesh. And I was trying to do this multi-sited ethnography looking at how these projects were put together from the City of London to the sites where they take place, where the ground is dug and drilled into. I started off looking, kind of follow these connections with a different project, this coal project in the northwest. But when I had got to Dhaka to do my fieldwork that I was doing there, people were talking a lot about this Niko case, and a lot of the people that I interviewed that were sort of lawyers or people working as civil servants in the parastatal oil and gas companies made reference to this, and I ended up going to these training events for arbitrators and meetings of arbitration lawyers and listening to how people talked about this case and starting to notice the extreme difference between how some Bangladeshi lawyers talked about it and some sort of international lawyers sent there to train Bangladeshi lawyers how to be more friendly to international business were talking about it. And then I really became interested when I was doing some follow-up research back in the UK, and I went to this training workshop for UK investors to learn how to use bilateral investment treaties and investor-state dispute settlement to sort of get the most out of their investments. And the trainer, who was from one of the Magic Circle law firms in London, gave an example of a really creative way that you could, use international law in a way you wouldn't expect to make sure you recoup your investment even if everything goes wrong. Use the same example that I'd seen described as this kind of massively egregious overreach overruling the Bangladeshi courts and undermining their sovereignty by a sort of distinguished lawyer in Dhaka. And that's when I started wanting to understand what exactly was going on with this particular case, not just locally or in Bangladesh, but trying to trace it out through the transnational legal spaces in which this dispute became dealt with.
What your episode does really well is kind of bring to life this like substructure that doesn't get seen behind these like spectacles of violence. You know, we see the blowout. You hear about colonialism being this really kind of uneven set of relationships. But what we see actually here is the kind of bureaucratic, kind of international systems and spaces through which that uneven relationship gets litigated, basically, and the kind of unfairness in the way that it's set up. But I wanted, kind of building off of Chantel's question asking about you, I also wanted to ask you a little bit more about the kind of people in the episode and I guess the human cost of this legal infrastructure.
Yeah, I think that's a really good question. And it also has to be said that by tracing out what's going on in these very opaque legal arrangements and tribunals, you do get further and further away from the actual blowout site, right, and the people who are affected. That's not something that I massively feel great about, but it also does parallel how these systems of law work, in that there is no right for people whose land was destroyed or who have gas bubbling through their water to be heard. The most you can get is sometimes people submit amicus curiae, sort of friend of the court briefs, just a sort of a comment that has no particular legal standing, and it's up to the tribunal whether or not they read it, hear it, take it under consideration. So there's no kind of formal mechanism for those people to be heard. And I think something that's also quite tricky in writing and talking about this is that you end up with a story of this system of international investment law that subordinates the governments of formerly colonized countries, right? And it does. Disproportionately, host states are ruled against. Disproportionately, they rack up costs. Disproportionately, money is paid out to large corporations and a handful of wealthy investors. But states also are complicit in extractive violence as well, right? There are plenty of other cases where there might be a dispute between the state and the investor that ends up in one of these courts that arose out of, protest against a mine or an oil well or a gas site that derailed it, led to the state being sued, right? But it doesn't mean that the state wasn't involved in violently repressing that protest. So there is a risk that in telling this story as kind of states being subordinated by a persistently colonial system of international investment law, the extent to which all kinds of states reproduce extractive violence, suborn extractive violence, can get a little bit missed. And I do think that is something I struggled with in this episode, because telling that legal story and tracing out that legal infrastructure does take you away from the local site and does take you into that story, which again is not without truth.
But you need it though. We need both. Do you know what I mean? And I think often, whether it's on material crimes, whether it's on shows we do on Surviving Society or other kind of work we do as social scientists, we do want to bring that human story, want to bring the people to the forefront. But sometimes we do miss the background and the structures that are at play because it's so because we're human beings and it's look what's happened to these humans. We need to talk about that in that way. But actually, what you do in this episode by showing the kind of background to the administration, the bureaucracy of the violence, is bearing witness in a way which we could probably do more of. So I'll speak for myself. So yeah, I think it's really good.
Thanks. Yeah. I mean, I think it is. Obviously, I think it's important, but I don't think it's more important than the sort of local scale.
No, but it is crucial because you only know what you know, and so many of us don't know or speak for myself, but I do think there's quite a few of us like this, like understanding the kind of financial infrastructure of how a harm like this gets reproduced is not common knowledge.
Yeah, and it's interesting because it has become more common knowledge it's sort of in the Anglosphere, I guess, in the North Atlantic over the last like 8-ish years.
Yeah, recent.
And that is precisely tracks on to the time period in which global North states started to get sued, right?
Indeed.
So once you had Canadian companies being sued under NAFTA, once you had the threat of TTIP, which people have maybe forgotten about now, but was at one point a big threat to kind of bring ISDS to Europe. And then more recently with kind of climate responsive legislation, you have like RWE suing the Netherlands, Vattenfall suing Germany. The amount of media attention, the number of sort of left liberal paper articles about this, NGO coverage has absolutely boomed. But the majority of the rulings, the majority of the huge payouts have been made by Global South states since the early 90s. You know, there were a few in the 70s and 80s, but it was the early 90s when these treaties went from like a few hundred to a few thousand, and then all the claims followed. No one really cared until it was sort of Canada and the Netherlands getting sued and the risk of the UK being sued. So I do think it has definitely been under the surface for too long, and in some ways still is.
This issue of removing risk.
Yeah.
And as an essential part of these super extractive, volatile practices that are inherently global because the companies that orchestrate them are global, the legal infrastructure is global. And the idea of, like, I guess, bureaucratic density maybe is the word I'm looking for, of like almost like layers upon layers of abstraction to remove risk. So I don't know, I kind of wanted to hear you speak more about it.
Yeah, this is something that for a long time I just thought I didn't understand. Yeah, I'm not a lawyer, I'm not an economist, I must just not get it. Why do companies that, you know, will claim that their right to earn a return on their capital comes from the fact they're putting it at risk, have so many instruments available to remove that risk, nullify that risk, de-risk, right? And, you know, it turns out maybe it's not that I'm just not understanding it, it's just that's how it works, right? So you justify your higher take because you're the one taking the risk. And this was happening explicitly a lot in the 90s as well, when a lot of countries around the world were rewriting their mining codes as part of a general push towards liberalization. There were sort of World Bank consultants helping people rewrite their mining codes. And a lot of them were based on the idea that, look, it's the companies taking all the commercial risk, so you shouldn't take too much royalties, too much tax from us, you know, too high % of nationalization. We take all the risk, we got to get the returns, right? But then at the same time, you have political risk insurance, you have bilateral investment treaties, you have the option to sue under an ISDS provision. And then you have the sort of infrastructural de-risking of these training courses where people go around the world and say, you know what, realistically foreign investors won't feel comfortable coming here if we don't have like global north trained lawyers to arbitrate for them who they know can sort of adhere to the rule of law, clearly shot through with all kinds of like racism and imperial assumptions. And it's also like, you know, to link back to what you were saying, Chantal, about it being a bit under the surface, I keep seeing it in all sorts of new places now, where like
on the pulse.
You know, sort of. Have you heard of the Just Energy Transition Partnerships? These sort of big funding schemes to try, bilateral aid schemes to try and facilitate just transitions in South Africa, Senegal, Indonesia, Vietnam. Massive schemes, so far proving to be a bit questionable about the projects they fund. But the paperwork for all of them has a little box, you know. In order for projects to be bankable, investors must be confident in access to arbitration. At present, the Vietnamese or Indonesian, depending on which document you're reading, arbitration provisions are not, you know, sufficiently international for these projects to be bankable. Now, what does that mean? Why does the quality of the not quality, but the nature of the legal expertise in your country affect the bankability of the project? Well, because clearly people are going to lend or invest to that project if they feel that there's a really good chance they can get stuff back regardless of what happens. So essentially creating these infrastructures of access to arbitration, changing arbitration laws, ensuring there are trained arbitrators in different countries who adhere to this particular way of viewing international arbitration, that is a way of making projects bankable by de-risking them, right? So essentially you have insurance if something goes wrong, and that can pay you out, but if something goes really wrong, you can still try and get your money back, right? And that's what ISDS allows, is for people to claim their investment and their profits back, often in situations where a reasonable person might say, but you invested, you took a risk, right? Why is this available to you as a foreign investor when all the local entrepreneurs and businessmen in the country can't go, my cafe or my factory went bust, can I have a payout? No, is usually the answer, right? So why is there a special bubble of justice for these guys?
Especially when it's an example like this one of an explosion that is caused by the company's neglect and mistakes that they make, but they still have an arbitration situation where they get a payout despite causing the problem in the first place.
Yeah, and that's a really interesting point, because there was some press releases announced in Bangladesh in 2020, 2021 saying that the tribunal in this case had found that actually Niko was liable for the blowout and they did have to pay compensation. And there were a whole bunch of press releases. The Bangladesh lawyers, Foley Hogue, they have this written on their website. But if that is true, it will be completely unprecedented. There has never been an ICSID tribunal that has ordered the company to pay the state compensation. I think it would be right if it is, hopefully it is true, and hopefully that money will actually make it to people affected. But that ruling is still sealed, because it's up to the parties involved collective consent over what documents are published. So half the time we don't even know what is ruled or the basis for decisions that are made. But it does seem that there is at least a possibility in this case that some liability has been found. How that will actually play out, given it's never happened before, and how it will be enforced is not something that's entirely clear at this point.
Is there anything you learn about the explosion, the blowout, in the process of putting this episode together that you could share with us?
I think there's a lot. I ended up contacting a few lawyers I hadn't spoken to and trying to get hold of some court documents from Bangladesh. I have a huge stack of photocopy documents, but I couldn't travel while we were putting this together because of the fact, and it's what you say about going beyond the written word, trying to put this into a narrative, a story, that there weren't gaps and footnotes. Sometimes there's like a little piece of the puzzle that doesn't transition very smoothly, right? So, and then I'd go back and read like the ICSID documents and read these other documents, and okay, clearly I have to find this court ruling or find a newspaper article about that day to make me able to figure out what happened so I can make it talkable. Right? And I think it has definitely left me with a better understanding of the timeline in a linear sense, but also just piecing all the events together in a way that you can actually speak requires, I think, more careful understanding than when you write about it, where you can kind of take an example, put it in a paragraph, wrap it up in some interpretation, jump to another example, use some theory, which I guess I've been guilty of before. So, I'm very grateful to Maya and Shari for ironing out my writing/speaking style as well.
No, you don't need to thank us. But I will say, I felt like the process of making the episode also helped us realise and this I guess is what you're saying, quite how complicated, how opaque, how technical all of these instruments are, and how prohibitive that is in terms of seeking redress, because it's so difficult to actually really understand what's happening kind of in its totality rather than just in these little pieces.
Yeah, for sure. And that's what, even we spoke earlier about, the fact that affected communities are not often given permission to submit evidence or be parties to these disputes. But if they were, how would they fund the legal teams to go through 10,000 pages of discovery? The levels of complexity are completely bewildering. And in this legal infrastructure, made even more bewildering by the fact that you can use whatever precedent you like and there's no appeal mechanism. So, when you think you know it, surprise, the tribunal can decide in a different way. There are layers and layers of impenetrability and sort of lack of accountability in this system as it exists at the moment. I found a few years back I had to kind of learn to listen to podcasts because I've always been a super visual learner, and it took me a long time of practicing for information to actually stay in my head. And so I really struggled with some elements of this, but I found it the bits like helping to make things seem concrete and placing them, like, you needed soundscape for it, right? So when I was in Bangladesh, I lived in a friend's house just by Karan Bazaar, which is the busiest vegetable market, wholesale market in the city, and sort of inside or on the edge of that market is where the Petrobangla and BAPEX offices are. So I thought, okay, if I want to place it, I'll get sound of this place, right? It's really distinctive, it's really busy. And there were a couple of things like that where I think it works more effectively to, remind people that this plays out in buildings, in places, some of which are easily accessible, some of which are far away and behind locked doors, and having to find that sound so that I could place people in the area I was talking about definitely made me think differently about how you kind of, learn through listening, I guess. I'm not sure if that's a completely coherent answer.
Paul, thank you so much for producing and creating such an incredible episode.
Thank you guys for your help.
Thank you.
Thank you for listening to Surviving Society.
To support our work, you can rate,
review and subscribe to host or produce a series of Surviving Society.
Get in touch with us via Twitter or Instagram.